May please, your lordship. My lord, I may be allowed to withdraw the petition, my lord. We want to withdraw the petition, my lord. Case is pending, my lord. Relating to pension, my lord. They are
Listed today? Or when is it listed?
my lord, tomorrow, my lord.
You want it to be listed for withdrawal? Okay.
Withdrawal.
All right.
May I, my lord, motion matter, my lord, may I pay for listing tomorrow, my lord?
What is the urgency?
Some urgencies there, regularization of my lord salary, salary is pending since last day.
We'll have it next week, okay? Don't give a date. Registry will give a date next week.
Then, my lord, let it be on Monday, my lord.
I'll not give a date. Registry will give a date, but next week.
May I please? So I'm paying for listing of two matters, lordship. Next week, lordship, I need it. Next week, I need it for admission, lordship.
For admission,
Lordship.
when was it last listed?
It was on the 3rd of March, lordship. One is 3rd
3rd of March. You approach the registry first. Yes, next.
Lordship, I beg to mention for listing one interlocutory application, your lordship.
IA.
Your lordship, petitioner salary has been stopped for the last.
Recently filed.
It was
new-
filed before vacation here. And it has already
You
been numbered, your lordship.
Filed and numbered, not moved.
Not
It's
moved.
not moved. Next week, okay? Next week.
Can it be on next Monday?
No particular date.
Because
Registry will give a date.
Last 2 months, your lordship.
It's okay. Next week you'll come any of those dates. The registry will give a date.
Of like-
Next week.
My lord, with the consent of other side, I beg to mention item number 6, 7, and 8.
Yes.
Pass over the matter and maybe any date on next week.
Why you want Passover?
My lord, the B. Kaushik is out of station, my lord, today. So,
Have you taken the consent?
yes, I have already taken.
For the petitioner, my lord.
Next week? Next week?
Next week? Yes.
On a mention made on behalf of Mr. B. Kaushik, London Standing Council.
Secondary education.
Secondary Education Department. Matter stands adjourned for a week to be listed on a date to be fixed by the registry. All right.
Yes, lord.
Any interim order? No interim.
No.
Okay.
May I give lordship? Lordship is a motion matter, lordship, so urgency matter is there, lordship. So may I please for it, maybe take it up tomorrow, lordship.
What is the urgency?
Urgency is there, lordship, a president of governing board of college, lordship.
Hmm.
Has been ousted, lordship, without giving a reason, lordship, and some new president has been, is going to be joined, lordship. So at the moment, they can convene the meeting, lordship, then my party will show in Hampal, lordship.
When is the order passed?
For the past, lordship, I got it on 9th, lordship, 9th July, lordship.
9th July.
Yesterday, I filed the case, lordship.
We'll have it next week, not this week.
So in the meantime, if they will, lordship, convene a meeting, lordship, then my part will be on difficult, lordship.
No, we'll
So
see
let
what.
me kindly on,
Hmm?
kindly tomorrow, lordship. Others I'll be sure on travel, most travel, lordship.
Hmm?
I'll want mass travel, lordship. If they can convene the meeting, lordship, then my part will be, lordship, in other travel, lordship. So, lordship, as early as possible, lordship, I need a word, lordship, order, lordship.
We'll have it on Monday.
Lordship.
Monday, not before that.
Lordship.
May I please? I beg to mention listing admission matter regarding pensionary benefit matter.
Sorry,
Pensionary benefit matter, admission matter. Next week matter.
when was it last dated?
Last plus 30 matter, 34.
34.
4 matter.
You approach the registry first, okay?
This pensionary benefit matter, nothing happening.
I understand. You approach and they'll give you a date.
Which one? We attend, lordship, Saturday is working day, lordship. This Saturday is working day, lordship. Can it be on Saturday,
I
lordship?
know it's a working day.
Lordship, then-
I have not given you a date just like that. There are many other things apart from your case. Yes.
Please, your lordship. I beg to mention matter for listing your lordship. Read petition, your lordship.
For what?
Admission, your.
For admission, when was it last listed?
6/6/2020.
6. Recently. You approached the registry. Yes.
I beg to mention for a listing of matter of admission column. Last listing was December 2024.
December 24. You approach the registry first.
Let's say
We'll see.
let's say I am a respondent
Hmm.
due to a stay order. My anything has been stayed, my lord.
I understand. You approached first. Okay.
Madam,
Registry.
just
Hmm.
Motion for listing lordship.
Motion.
Lordship, admission lordship.
When was it last listed?
4/4 lordship.
4. You also approached the registry.
Lordship.
You approached the registry. Okay. We'll see.
May I please, lord?
Yes.
My lord, I beg to mention item number 4, my lord.
Yes. What do you
My
want?
lord, in this case, my lord, the petitioner has filed a reply affidavit, my lord.
Hmm.
It is not on record, my lord.
You want to call it?
My lord, can it be on 24th, my lord, next Thursday, my lord?
You have received a copy?
No, I have filed, my lord. I am for the petitioner.
Oh, you're for the petitioner.
My lord. I have filed a reply, my lord, to the affidavit filed by the, my lord, respondent number 1. On next third is my lord, urgency is there because the challenging the my lord, constitution of the.
List the matter again after a week on a date to be fixed by registry. Item 4. All right.
Can it be date?
After a week, they'll come. Okay.
May I please?
Yes.
Lordship, I beg to mention for listing of 5 writ petitions, similar writ petitions, Lordship, in the
Listing for what?
writ petitions.
For what? For motions, order, admission, hearing? When was it last listed?
Was last listed on 21 May,
21 May. You approach the registry. Okay, first.
the first week of August, Lordship.
You approach the registry with the request first. Okay.
Registry, directly.
For orders, item 9.
Item 9, Lordship, there's a meeting held on today in an office of the Secretary, Lordship. The director of SCT has been called for with the record. Let's kindly take it up on next Friday, Lordship. Let the outcome come, Lordship.
Mr. SM T. Chisti, learned counsel, appearing for the respondents, submits that a meeting is scheduled to be held today in the office chamber of
Of the Secretary, School Education.
Secretary School Education.
Yes.
And therefore submits that he may be given a week's time to come up with the status of the meeting.
Yes.
In view of above, list again after a week on a date to be fixed by the registry.
I appear for respondent number 3.
Mr. S. Bora, learned counsel, appears for respondent number 3. Madam, your name?
For the petitioner.
Your name?
Please, sir.
Ms. B. Sharma appears for the petitioner. Okay, record her name. Yes.
Item 10.
Item
Content matter, my lord. That matter came up before earlier also, my lord. The 2 order has been, they were complied with, my lord. First order passed on 2019. Second order passed on 2020, my lord. But till then they have not been, my lord, complied with. Litigation going on since my 2016, my lord. Is a person, he appointed in 2000, my lord, 1985, my lord. His service has not been regularized. Other person has been appointed at the same time, they have been regularized. But with 2019 order, my lord, that is, my lord, fine at page, my lord, NSR 13, page 16. Lordship asked,
Just a minute.
that is the order, my lord, asking to, my lord, regulatory service, instead of regulator, my lord, they have by giving her a fixed pay, then I file another writ application, because, and this, next situation, your lordship had held that, my lord, because already order is there for compliance with that, order is there, no need to go for further direction, so ask them to file, my lord, to give a direction to comply with the order. So even then, my lord, they have not been complied with, my lord, from 2024, my lord.
Mr. Counsel,
Yes.
please wait for a minute. I'm reading the order.
Yes, yes, my lord.
Okay. What has happened to your review?
Well, Lordship, item number 11 is the review.
Yeah, why is it listed today? For what purpose?
For first time it has been listed, my lord.
Hmm?
First time.
First time.
First time, orders. My lord. What had happened is, my lord,
Hmm.
if Lordship take up my review petition, my lord,
Hmm.
the order what will find page number 49, my lord. This is the order, my lord, 6/9/2019 for review. Page
Which is the
49.
order you're seeking for review? Page 49.
Page 49, my lord, the order dated 6/9/2019. If Lordship turns to page number 50, paragraph number 7. That's the issue, my lord, had come up, my lord. The learned counsel for the petitioner submit that there should not be any difficulty on the part of the authority to give regular pay for the reason that when the petitioner was initially appointed in the year 1989, though with a fixed pay, as per his appointment was a compassionate basis. Normally, compassionate appointment under the normally the appointment made under compassionate basis is to be made on regular basis, fixed with a fixed pay. The issue is that, my lord, that there is a submission from the petitioner side. This is an appointment under compassionate basis. In fact, it is not a appointment under compassionate basis, my lord. Lordship will turn to
No, let us complete the order. What is the direction?
to give Now, next paragraph, my lord. Be that as it may, since the petitioner has working since 1986 and the post held by the petitioner is retained permanently with effect from 1/3/2019 and also normalized with wide government notification number so and so as nominated in paragraph 7 of the petition opposition filed by the phone number so and so. The court is of the view that there should not be any difficulty on the part of the authority to grant regular pay to the state grade 4 post of sweeper held by the petitioner since 1980 and had been permanently retained. There is no difficulty, my lord.
Regular pay.
But a regular pay and everything. There is no
So what is the review that you have sought for?
because this person is not appointed as a compassionate appointment.
That was his submission.
That was sufficient. It was-
Court did not say that this is appointment of compassionate basis.
No,
Court has held that he has been working since so and so and the post has been retained permanently. This is as per the paragraph number 7 of your counter affidavit.
Yes. Then
So in view of that, court had directed give a regular pay scale.
regular pay scale, the only thing is that the compassionate.
No, compassionate appointment is not a decision of the court. It is only a submission from the counsel for the petitioner.
That's the reason because
That is the reason for review.
That is the reason for the review. Not will
Well-
clarify it, my lord. This is not a compassionate appointment because the petitioner itself also in there is no pay of a compassionate appointment.
But what is there
the
to
submission
clarify,
statement-
Mr. Bora? The order speaks for itself.
My lord, lots will clarify. That's the reason, my lord.
Like today we hear a case, counsel for the petitioner submits, I record. You submit, I record.
My lord,
Then ultimately court takes a decision in the matter. So your submissions recorded, it is not the court's decision. So
No.
this is only a submission from the petitioner that
no, no,
I
that
was
is-
appointed
there
on
is-
compassionate
there is also-
basis.
There is a defect in the record also. So turn to page number 13 or affidavit also. Though it is not exactly said as a compassionate appointment, my lord.
Hmm.
It is said that the father has expired, my lord. That's transpired that submission, my lord. Ultimately, that petitioner, it looks that the petitioner was appointed, but it is on a compassionate basis, my lord. Lords will turn to page number 39, the affidavit, my lord. Paragraph number 5, my lord. The compassionate basis appointment will be under the scheme, under compassionate appointment, not by regular appointment. Page number 39 is the part of the affidavit, my lord. Paragraph 5, my lord.
Hmm?
That one line has been added by that
Yes, what
affidavit
is that?
itself, my lord. That the deponent beg to state that the petitioner was appointed as a sweeper of PGTC by Ram Lal Baspur. His father expired on temporary basis. That is the fact, my lord. But person was not expired. It is given as whenever the appointment. Lordship will kindly see the appointment letter, my lord.
So the father expired, isn't it?
No, father didn't expire, my lord. That is also that's the one of the reason, my lord, that transpired the submission that it is a compassionate appointment.
But this is your affidavit.
My lord, that itself is
It is not the petitioner's statement. It is your statement that
But that itself is an error, my lord.
somebody
that's a-
died and in place. the
No,
per-
nobody
but-
died, my lord. His father didn't.
No, the statement says that.
Statement says no.
Petitioner's father expired, so in lieu, somebody was appointed. He was appointed.
Actually, father has not expired, my lord. If lordship turn to page number 26, is the appointment letter of the petitioner without any selection process, my lord. Page 26, my lord. There was a post lying by the post of sanction, no provision for any interview or advertisement was called for. It was straightway he was appointed, my lord, because he happens to be the son of the person, my lord. So,
He happens to be
son of the person who was earlier working, my lord.
earlier appointee retired.
No, he didn't retire, my lord.
Then
He didn't like to work, son was entered. Because the post has come up, son was asked, you work. That is the
Okay.
process. The
father was replaced by the son.
father was replaced by the, without any, because a post has come, government has sanctioned it, and without any interview, this person has been appointed. So and so is appointed on 6/8/1996 in a college in place of so and so, my lord. No, it is not late, my lord, or nothing has been there, my lord. So and so in fixed pay. This father didn't like to work, so son has been.
No, what is the ground for review? Let's see.
My lord, ground for review is that, my lord, Nirmay did a compassionate appointment, my lord. Ground starts from page number 7, my lord. Because while appointing the person, the Article 14 was not followed. It was just an appointment. Because the post has come, no advertisement was there. They have never complied the provision of Article 14 with an advertisement, my lord. And it was never a compulsory appointment because it is appointed during the lifetime of the father.
This may be ground for appeal, not for ground for review.
Well, they have one of-
You know very well what are the grounds for review. It's a limited question, limited area wherein the court can exercise its review jurisdiction.
That this is not a compulsory appointment, then we are ready to give him, but the compulsory appointment, moment the compulsory appointment comes, then it is under a scheme. Neighbor was appointed under a scheme, then the things becomes different, my lord. Because it will be under a scheme where the father has expired, dying in harness scheme, my lord. It is not appointment as such, my lord, how the petitioner was appointed on 1986, my lord. Because it was not appointed under a scheme, it was straightaway appointed because there is a requirement of a sweeper, a post has come, then straightaway he has been appointed. Lord, you will even see the page number 12, my lord. The post was created by on the direction of the government, my lord. Since the post was there and earlier the father was working there, he was straightaway inducted in the post. My friend will also have no difficulty. We are ready to, the only thing the compulsory appointment will come in between, my lord.
No, you are ready to do what? Pay the pay scale.
Do it as per Uma Devi, he has worked it and the process will be done and completed. The moment we went for the process, then the issue came with.
No, then what is stopping you? If you're ready to pay the pay scale, pay the pay scale.
Well, pay scale, the moment that compassionate part comes up, my lord,
Hmm.
then under the scheme we have to appoint it. Here the person has worked without just a later he was inducted, my lord.
Compassionate appointment is not the court's decision, I think. It's only a submission made. And how do you say that the father did not expire?
My lordship will see that there is no late before the person, and when the lordship
There is
comes
no?
up late. On that particular day, lordship will come to page number 13.
Page number?
13. The appointment letter, my lord. The appointment letter was issued on 16/8/96.
No, this can be very well be a typing mistake.
No, my lord. This is not a type. I will show you another lordship, their own petition. I will show you. Page number 17 is the writ petition, my lord.
Page number?
Page number 17.
Hmm.
And only will come to the first lot will come to the cost title. Page 19. So and so, son of so and so. Never he is 7 at the late. Lots will come to lots will come to page number 25, the affidavit. It also said the person is alive. Page 25 is the affidavit, madam. My senior friend will also say that this person was never a compulsory appointment and this person was alive on the date of appointment, madam. We want to take a decision because only this hurdle has come, because it will be on a scheme, my lord. Because the moment that compulsory appointment comes, it will be in a form of a scheme. Then there will be no requirement of following Article 14. Straight away there is a post, give him, and this compulsory scheme will come up.
What difference would it make?
Because they have
Direction is to give a pay scale.
pay scale.
You are
that
ready to give the
particular
pay
date.
scale.
He will be inducted on a particular date from the under the compensation scheme, and all the remuneration have to be given from the particular point of time. My lord. It will create.
No, that is not the direction of the court. That he is indeed a compassionate appointee and you should give him so and so. It doesn't say that. He just said that give him a pay scale.
Pay scale, because from that part, paragraph number 7 has come. Lordship will clarify it, my lord. Will take a decision, my lord, because the process was on to take a decision. Then this issue has come up.
All right. Yes, what do
My
you say?
friend agrees, my lord. No difficulty.
You are there in the review also. You have got a copy.
No, review not. This is for the first time, not.
Huh?
But he knows this is for the first time, my lord. He has not even filed a
Review has
case.
come for the first time.
First time, he has not.
You're not aware about the review.
He told in a court before this court, my lord, that he's going to file a review application. but copy has not been served.
But this is recently filed or what?
No, this was filed, but it has come for the first time.
When was it filed?
Was filed 25 to 2025, I think. Because my,
Only thing, my lord, Rossi, we allow permit, my lord, only very rare of the rare case review can be, my lord, allowed. First, my lord, there is error on the face of the record, first, and second, my lord, is, my lord, due diligence certain matter before your lordship, at the path of at the passing of the time of the.
That's
judgment.
what I was
These are
asking,
two
Mr.
my
Bora.
lord. That is a various, Supreme Court, but till today, my lord.
No, that is
So
what I
going
was,
the face of the
that is
record.
what I was asking Mr. Bora also. On what grounds can review be maintained? That is a ground. So the order was passed in the year 2019. How come you filed review in 2025?
my lord,
There's some delay.
There are some delay. After that process, my process was initiated to give in that particular, comply with the order. While complying the order, it is from the Jurat, my lord, appointed. Then the record came, on inspection of the report, it came out that it wasn't, without following the Article 14, this person was simply appointed by the principal. And since he has worked more than 10 years, my lord, we want to proceed, my lord, and give all the benefit. But the problem is that he is not in a compulsory appointment.
And contempt also filed in 24.
One time also filed in 24, my lord.
24.
Why is that?
So
Because-
when you initially file a, my lord, first rectification, that rectification, my lord, after passing of the first rectification, my lord, they have given me the only one of fixed pay. They have to file, we have filed another application, my lord, with a presumption, then where they say order has been complied with. So on that ground, we file a second rectification, and second rectification, my annex with that, my lord, contempt petition. Then when the lordship says, say, my lord, there are no need to pass face order, my lord, there already direction is there. They have to, when they have not complied with, my lord, then we file this rectification. Contempt application, my lord.
Gross willful violation of the order dated 16/12/2022. 16/12/2022.
After that order, my lord, they will issue a notice, my lord. That's why, after second lead application, we have actually appear before the, my lord, authority. I appear, my lord. Thereafter, they file this and come with the idea of the review application.
What do you say about the compassionate appointment?
We have never say, even first.
No, that's what.
I've never.
Sir,
said,
the
Kali
Lordship will only clarify, this is not a complaint, we'll
We have
straight away
never
go
said
proceed
complaint,
and
my lord.
give the relief.
Copy of it, I have the first, I have copy of the first letter.
See,
Lead application. And
Ye-
they say they want-
Yes, I have annexed it, my lord. With petition, I have annexed it, my lord.
Where is
this-
Well, your affidavit not say anything about the completion.
writ petition of 2016
16,
was
right?
disposed of on 2019, correct? Thereafter, you filed one more writ petition in 2020,
Yes, sir.
which was disposed of on 2022.
Yes.
Court says that already there is one order, not to, we don't require it,
This order.
pass a subsequent similar order.
Yes.
So the previous order will cover that. So that was not complied with, then you filed contempt. And contempt was filed when? In
It was filed-
2024.
2024, my lord.
There is also a bar, isn't it, in contempt also? You have the Contempt of Courts Act? What is that section?
20.
20?
20.
Read it section, my lord.
Not only two, it will,
215.
215 of article,
Constitution.
constitution will not come out.
Court of, court of.
Because the decision of the
215.
apex court that you have to be strictly in the section 20 of the contempt act.
Constitution?
Then,
There,
giving
Constitution.
that Article 215, my lord.
Article, no,
20.
section 20 says, no court shall initiate any proceeding of contempt either in its own motion or otherwise after expiry of period of 1 year
1 year.
on which the contempt is alleged to have been committed. The earlier order was passed saying that action should be taken within 4 months.
It is passed on, or the order
Hmm.
is 6/9/2019.
4 months. 4 months from 6/9.
6/9.
No, 4 months from the date of receipt of a certified copy of the order. So when was the certified copy of order received? I think with 1 month, perhaps within 1-2 months, you must have received it. Both petitions are hit by delay. Contempt also, this also.
No, no.
And he says compassionate appointment, nobody's case is a compassionate appointment.
That is the reason I
That's-
told- I introduced Article 215. What Article 215 has same as the court of record. Kindly go to the
That's all.
Article 215, my lord. The decision of the Supreme Court is also there, my lord. In other courts, my section 20 is applicable, but in High Court, my lord, order passed by the court, Article 215, it is court of record, my lord.
So,
Kindly see, my lord. And there is decision of this court also, my lord. The decision of this court also, my lord. There is no delay for filing contempt.
no, 215 is again limited by the Limitation Act, isn't it?
Limitation Act.
Otherwise, anybody can file any contempt petition anytime.
Yes, my lord.
Order passed in 1970, today they'll come and file contempt.
Lordship.
There'll be chaos.
And another thing, my lord, sir, that is I filed this second writ application, my lord. Second is filed on 2000. That is filed on 2022, my lord. 20, my lord.
So my friend will agree that this is not a compassionate appointment. That is the, he also agrees, my lord. Only thing is that Lordship will clarify it, then we can proceed and give him the relief, my lord. We wanted to, but moment that compassionate point comes up, my lord, then the hurdles comes up, my lord. Because they have called the record from the Jorhat and after that we proceeded, my lord.
So we'll close both the matters.
Clarifying it, my lord, will proceed.
We'll say that this is not a case for review. Nevertheless, the
Appointment was.
understanding of the respondent that this is a compassionate appointment is not correct. That clarification will be there.
Lordship.
Okay.
That correction will make it clear, my
And
lord.
they're ready to pay the
Will-
regular pay scale.
Lordship.
It appears so.
And regarding.
Only thing is that they're afraid that if they take it as a compassionate appointment, then you may come and claim your appointment right from the day one with all the benefits.
There's it, and the.
Direction was not like that. It was just to give you the
Because second order, my lord, kindly see the second order, my lord.
second order.
Second order, kindly see, my lord. You barred by the kindly the second order, that is, my lord, page 20, my lord.
20 of your contempt.
Yes, my lord.
Second
Sorry,
order is on page 18. Page
Page
18, order
start with
dated
page
16/12/2022.
Page 17, started from page 17.
17, 18, 19. 3 pages only.
3 pages.
ठीक है।
Because there is already an order, it had to proceed. In 1987.
But what does it say here? It appears that the direction of this court dated 6/9/2019 has been complied with.
Next, my lord, kindly the next paragraph. With approach, the present situation stands close with a direction to consider a pair of the petitioner, my lord. Consider a pair of the petitioner. Well, I'll say, my lord, these two paragraph, my lord.
I don't know what is
There is no, first, my lord, comply to, second
That's
say,
why,
my
my
lord,
lord,
to consider pair of the
it was,
petitioner.
the process was initiated by the department, my lord. And their hurdles came later on, man. Then we have to.
Thereafter, my lord, I have filed all the, this application I have filed before your the authority concerned, kindly turn to the next page, my lord. Page annexure 3, my lord. I have submitted the application by order, my lord. Next. And annexure 23, my lord. Page 20 is annexure 4, my lord. They will ask to appear with the document, kindly see, my lord.
Because we started the process, that's why we have asked the person to come with all the documents.
Last page, my lord, of the contempt petition. Annexure 4, page 23. Which refers to the above, I am informed that hearing regarding regulations have been necessary upon pay held by CSR going to be held on 15/7/2023 at 1 PM in the office chamber undersigned. We are therefore requested to present in the hearing on the day and time possibly with all original document and files and record to a matter able with you. After this order, I appear, I am waiting for some favorable direction. They have not been given any favorable direction. They I filed this contempt petition.
Okay.
Very poor people, 85 he is working, my lord. Only, my lord, he is giving more than, my lord, 40 years in service, my lord. And I will inform, my lord, last day before he is suffering from stroke also because of this case. He is in hospital, my lord. This person, my lord.
So I'll do one thing. I'll close this contempt petition and whatever process you are undertaking, you go ahead. Go ahead with that. And in review also, we'll say that this is not a compassionate appointment,
Then we'll straight
but
away
we'll dismiss
proceed.
the review petition.
Not only, my lord, if I lordship, my lord. Contempt is pending, my lord. Till, whatever pending, let the what they say. my lord.
No. Why should it be pending?
Well, Kali-
You have, I have read section 20. You have also read section 20.
In that case, when I comply, I satisfy your lordship, my lord, whether this, my lord, this petition can be entertained or not. This will not be for it.
Hmm?
It's a preliminary issue. It should be raised at the very first street, my lord.
No, it can be raised at any time.
And
You
that's
don't
why-
have the absolute right to audience. See, once a contempt is filed, you are there to just to set things in motion. To bring to the notice of the court, this is not complied. Then the court will take it up with the
Yeah.
alleged contemner. That's
Very
all.
limited.
Your role is very limited.
No, my part is very limited. I know.
That's
my lord.
why, that's
Very
why.
less. But there is, our decision is there, my lord. That can I be. The decision of this court is there, my lord.
That what?
Regarding the contempt petition, my lord, in High Court, my lord, order by Honorable High Court, my lord, there is no limitation. I can place the decision, my lord. I can place the decision. Decision is there, my lord. The decision is there, my lord. The decision of this court, my lord.
Article, section 20 is clear. It says no court, no court.
That is applicable by the order by the other court, not by the High Court. The High Court is a court of record. In that case, when it is a court of record, my lord, in that case, my lord, the constitutional limitation is not come, my lord.
I don't
Right.
think,
In
I
that
don't
case,
think
my
there's,
lord,
there's any
That is
such kind of
not- that is
judgment.
by that the order was by late, my lord, Justice Jain Sharma, my lord. At that case, I have appeared, my lord. And that case petitioner appeared, my lord.
Show me the
That-
order there.
And that case, my lord.
Show me
that
the
is-
order.
I can place the decision also. I can
Show me the
place-
decision.
I bring the decision, my lord. And that case, my lord, found the container, my lord, sorry, my lord, for the petitioner appeared, the then advocate, my lord. Then advocate, let PD appear in that case, my lord. In that
So
case, my lord. I
you
can-
have
I
to
can
show
place the
me.
decision, my
You
lord.
have to show me.
My lord. I can,
You show me the order. Let's see.
I can place decision also.
How do you overcome section
Decision
20?
Decision is not there, my lord. I can place the decision, my lord,
When? When will you place it?
next week, my lord,
Next week.
next week.
No difficulty, my lord. I can give the 3 citations of that section 20 will be compliable. Section 2, Article 215 will not be applicable, my lord. Since section 20 is there, the Supreme Court decisions. I don't have that judgment, my lord. I can give the citations right now, my lord.
I have the decision, my lord.
You want some time to produce the decision?
Yes, yes, right. Yes,
I was thinking of closing both the matters
No,
now.
that will be beneficial for the petitioner itself, my lord. I want to finish it off, my lord, to get
Next,
the benefit. my lord.
only 1 week, my lord. Next Tuesday, next Tuesday, next one Thursday or Wednesday, any day, my lord. Tuesday.
As straightforward, the parties matter stands adjourned to be listed again on Tuesday,
Tuesday, no, not Tuesday, my lord, Thursday.
Thursday, okay. Be sure to get the thing, we're closing the matter.
So my understanding, my lord, section 20 is applicable order by the other courts, not by the High Court, my lord.
Okay, we'll see. Anyway. Thursday, isn't it? What? 18 matters already. And what about the other days? 25 is what? Friday? Will it be possible Friday? How many matters are there? We don't know. Mhm. Mm. No, it's okay. We'll see.
I am available in every day, my lord. Lordship is fixing on.
We'll have it on Thursday.
Lordship.
Or I have got the information that there are many cases on Thursday. Friday is slightly free.
What my friend says, my lord.
Just ask him. Friday.
Nada.
We'll have it on Friday.
That is
Next
on
Friday. Next Friday.
25th, my lord.
Next Friday. Thursday is a lot of cases.
Lordship.
Okay, it may not reach. That's why. Make it Friday then. Okay.
Okay.
10 and 11, similar orders.
Similar order. 10, 11. Yes.
For admission, item 1.
May I please, your lordship, the matter relates to the refund of the notional and the retirement benefits which has been deducted from the petitioner's account. Your lordship, I have received the instruction. I require 2 weeks' time to file my affidavit, lordship. Date may be stationed.
Your good name?
K. Jain,
Mr. K. Jain, Landed Council appearing for the
on behalf of SCKL, for the Assam University, lordship.
Assam University, submits that he has received instructions and that he will be able to file counter affidavit within 2 weeks. In view of above, list the case after 2 weeks on a date to be fixed by the registry.
Lordship. Much appreciated, lordship.
Item 2.
What's even last order? That is on 19/6. There is some, my lord, specific instruction in view of the order passed in on 5/6/2025. My lord, there, my lord, the education department higher as well as, my lord, elementary, both are, my lord, entered in this case, my lord. So the court wants to know under which jurisdiction, my lord, this has come and to whom did the instructions should be issued, my lord. So in that aspect, in the earlier occasion, all the advocates appear and they're taking time for obtaining instruction.
Two
my lord.
departments.
Which department? Because, my lord, as per our, my lord,
Which are the departments, probable departments?
Actually, my lord, this is elementary, it's come because BA
Elementary.
is come under elementary, but whenever the course, my lord, relating to BA, BEd and BSc BEd integrated. So now, my lord, the higher education, they are also not sure whether this department will come under them or not. But that is why, my lord, the court, at the intervention of the court, that was given a direction to the respondent advocate concerned to obtain the instruction regarding which department they, because the court, if it is going
Petitioner is working under what?
not working, but this is regarding the affiliation from the Guwahati University, regarding to start the courses of BA, BEd and BSc BEd, my lord. It is
No,
relating to affiliation.
Who is the petitioner?
Petitioner is a Hameke College of, my lord, Education, my lord.
College?
Yes, my lord. It is a private college, my lord. It is not government sponsored college, my lord.
And what are you seeking?
Well, I am, well, seeking because, my lord, I applied for the affiliation and the affiliation for that purpose, they.
Affiliation to?
My lord.
Affiliation to what?
To start the course, my lord, BA, BEd and BSc BEd, my lord. Because, my lord, any course to be, my lord, started before that, the precondition is required, I got the affiliation, then I got the approval from.
No,
the-
affiliation to some
Yes,
institution,
start-
some university.
Yes, yes.
Affiliation to university.
No, affiliation to the, from the university to start the course in the college, my lord.
My lord,
Which
first
university?
affiliation from Guwahati,
What university, my lord?
then recognition and approval from NCT.
And sir.
Then they will start the.
So on the issue of the affiliation, the matter is hanging, my lord. My money has been received by them, they as per their instruction-
Petitioner is a private college.
private college. my
They
lord.
want to start BEd,
BA, BSc and BA, BEd and BSc BEd, my lord. Integrated.
BSc, BEd and BA, BEd. You
Yes.
want to start that.
Yes, my
An affiliation has to be given by
lord. What university?
what university?
Yes, my lord.
And then once affiliation is given
Then I go for the, my lord, approval and the recognition from the NCT, my lord.
from the NCT.
NCT. Without recognition, without affiliation, approval.
So
from
now
the-
what seems to be the problem?
Problem is without getting,
NOC.
my lord, affiliation, I cannot go for the, my lord, recognition of the, my lord, approval from the NCT, my lord. This is a prerequisite condition.
And regarding
You,
that.
you are not getting in affiliation from the university.
Yes,
They're not giving you.
yes.
Why is that?
Inspection.
In view of
initially, my
that,
lord,
in view of NOC aspect, my lord, NOC from government, that is.
well,
what, my lord,
NOC part is,
Oh.
we don't know, my lord. From the very beginning, their affidavit also not saying that the NOC is required. They take different steps in different stand, my lord, taken in different stand, my lord. In 3 para, they have taken different stands. In all 3 paras are not consisting to each one. And the second thing, my lord, later on, my lord, they come with another standing that they, without giving the NOC from the government as per one OM, my lord. But interestingly, my lord, OM cannot override the, my lord, statute. They, my lord, insisting on the OM as part of OM
Okay.
is something is saying that if you are, somebody is going to, my lord, start an institution or education, whatever may be, my lord. But there is a condition that if the institution in future seeking any cost, my lord, any, my lord, help or any, my lord, finance or any this affiliation or my lord, the regulation of service and that aspect only, the NOC is required. But so far the private college is required, concerned, my lord, the NOC is not required. My lord.
Okay, okay,
Yes,
okay.
my lord.
See, NOC means you are already affiliated, isn't it? Otherwise,
Not affiliated, but
Not yet.
I have started.
then how are you running the college then without affiliation? Sorry?
I'm not running the college, man. I'm waiting, my lord.
Or you're intending to run?
Yes, man. My
Okay.
already inspection has been done in one time.
Okay.
One set of inspection has been done on the basis of, my lord, the affiliation committee, my lord, satisfied with my all terms and condition, my having my full.
This petitioner college has not started operating.
No, it's
You
not-
want to start operating, but
Yes,
for that affiliation is required. And when you go for affiliation, they said that first you get NOC from the government.
Yeah, but
NOC
affidavit,
from
my
which
lord,
department?
but the interest-
Secondary or
Ah.
elementary or higher? That
Okay.
was the question.
But
But
then-
where is that criteria for getting NOC?
no.
Under
The
what provision?
NCT, my lord, the act is also, act itself also not require any NOC, my
No, no,
lord.
I'm asking him.
Yes, my lord.
Whether-
And so far, the Supreme Court decision, my lord, I will coming on that decision also. There no, where it is saying that whenever the statute of the state and the central will be conflicted, then the always central will be prevail. And this university cannot, their own motto, my lord, said anything which is inconsistent with the condition of the central act, my lord.
All right, fine.
This-
Yes, Mr. Pukan,
my lord.
where is the requirement to get NOC?
My lord, it's my affidavit, my lord. May I, my lord?
No, are you referring to any particular provision?
My lord, yes, my lord.
First, you should get NOC, then we'll consider like that.
2019, my lord. It's a state university, my lord. So state government issued an office memorandum 2019.
Regarding,
that NOC would be required.
where is that? Show me. You've done inspection already, isn't it?
My lord, inspection is.
Inspection is done, my lord. Inspection, they satisfy first.
Inspection is done by university.
University.
Hmm.
The two inspectors are appointed. They have submitted their satisfactory report. On the basis of that, I was directed to pay the affiliation fee also.
Hmm.
I paid my lord 4,84,000 already.
Hmm.
But after payment of this this affiliation fee, they were again insisting for another inspection by constituting two members, two committee consisting of 3 members each committee, my lord. So on that my lord, inspection they have done, and subsequently another inspection also they done. But but till today, they have not informed me regarding what they come out with the inspection report, even in deficiency, nothing was there. So nothing has been communicated. So it all communicating this anything.
So you filed writ petition.
Yes, well.
Now, what is their reply?
No, well, there are no reply. They simply came in the first affidavit. They're saying that one police case has been registered against me, my college, and they asked on receipt of some the communication from the DIG CID. They were not insisting that we are not giving the NOC affiliation to my college, and another they contradictory statement also taken that they I have not applied for the affiliation. Again, they have taken another different statement standing that I have subsequently I have filed another application for affiliation. So all are not consisting to each one. So all are contradictory. So my humble submission, whatever they are coming with this stand, that the NOC is required on the basis of an OM, that cannot be survived because the OM cannot survive when they override the statute. And if the statute is not saying anything, in earlier occasion, the Lordship, Ravin Pukan also asking that whether any provision in your statute that you to start the affiliation, to give the affiliation, any NOC is required. One way they are saying that they are autonomous body, but on the other hand, they are saying on the instruction of the government, they are doing well. So this is the contradictory total statement. On that issue, the last occasion, Lordship has asked the department concerned that if some instruction is to be done or given, that to which department that will be given.
So, which is the department?
So now,
Anybody
Kosi
can
and
tell
the other way there on that day, all were at present. The Lordship will go by the order 6,
Department.
5,
You are
6.
there?
Understanding there will be higher education department.
Oh, you get instructions.
Understanding will not do well. That is that.
We're not asking your opinion.
Concrete.
Concrete.
They have to bring instruction. Other
Because
things that,
Lordship may not. Lordship may have a look at the
See-
order 5, 6. My Lordship.
There's already an order
Yes,
asking
I
you
see
to get
something.
instructions, so you should have got the instructions. We're not asking your view. Department has to come up and say that, no, this belongs to the higher education, this belongs to the elementary or whatever.
Yes, my lord. Otherwise, my lord, BEd is an elementary, my lord. But as the question is now, the BA, BEd and BSc BEd, both are integrated. So,
BA, BEd and BSc BEd.
Yes, so,
Higher education will come.
but
you
education
get-
part
get
is
it
still
confirmed.
with the elementary.
Hmm.
Elementary is still dealing with the BEd, my lord, still.
Only BEd part, not the BA and BSc degree.
That is why, my lord, so it is some sort of clarification is required. So that is why Lordship.
BA, BSc is dealt with by elementary. Then what is that elementary you said? BA degree is dealt by the elementary. I see.
But they are not sure, higher education also not sure, my lord.
Hmm.
Under which permit that's come. So that is why, my lord, Lordship at last order, which is 5, 6, my lord, there is a specific order, my lord. 5, 6.
Other thing is that.
It is a law.
There are 6 of the affidavit, but they have mentioned regarding the office.
Para 6 of whose affidavit?
There, my lord, office memorandum, only there is there.
Office memorandum, it is regarding the, my lord, government, if some institution is in future checking for. a
Paragraph
government fund,
number?
Not for the private college.
Hmm. Which paragraph number? 66.
Second affidavit, maybe.
66. I think there's something wrong with your pagination and my pagination.
Second. 51 of the start.
66 এখন প্যারাই নেই, পেজই নেই কে।
66, something
This
else.
second affidavit starts from page 61 up to 70.
Paragraph 6.
Yes.
66.
এফিডেভিটটো দিয়া নাই নেকি হে? নাই দিয়া।
Government office member নাম আছে নেকি কোনো?
Office member নাই নেকি?
Office member 19. তুমি এখন
ও এইটো নেকি? এইটো সিট এলসিটি এইটো।
Milord, regarding
Who will clarify?
Milord, the state government will have to clarify. Otherwise, Milord, Milord, this is integrated.
We are not giving explanation of this. So they have to pay kind of whether NOC is required or not. Now they are shifting the burden to the Department of It. It is their compensation. They have created this compensation of it. Whether NOC is, petitioner said NOC is not required.
Milord, first thing,
My lord, one day when
first thing, NOC from NOC.
So question now is who will give NOC? Supposing NOC is. No, supposing NOC is required. If it's not required, no issue. If required, then who will give?
We are nothing to do with the affiliation of it.
Milord, that office memorandum has been issued by the state government.
So produce that.
I
Where
will,
is that?
Furnish Milord,
Where's the OM?
Milord.
My lord, my lord, one document that is annexure 1 at case 23, my lord. From this, case 23 of my reception. Because my lord, so far the yet is concerned in the state level, that is being regulated by the SCRT, my lord. So SCRT inspected my institution, and the joint director, my lord, of the director of the said SCRT had written a letter to the, my lord, the secretary to the Government of Assam Elementary Education Department, my lord. Lordship got it in annexure 1 at case 20.
Yes, what is this letter?
This is a, my lord, regarding all satisfactory inspection report in respect of the to start the course of the BA, B.Ed and BSc B.Ed, my lord. It is written by the SCRT. They are the authority, my lord, in the state. They are the authority. That is why they written to letter to the director elementary, my lord, not in the higher. It is clear from the communication. Otherwise, that is also to do both the department, my lord. They are gone on to the elementary.
Hmm.
Now they are creating the problem, and they are the university is creating in doubt, my lord, in every aspect, my lord. And affiliation so far is there, my lord, they cannot go beyond the statute. The Supreme Court says, my lord, in the case of the, my lord, the Gokul case and the others, this another case also, my lord. It is decided by the SIC College of, my lord, Pharmacy, where the lot of, my lord, Supreme Court judgment also discussed, where it is specifically stated that when the NCT is concerned, they cannot go beyond the, my lord, statute of the provision of the NCT. University only to show to the aspect of the, my lord, the curriculum of the education, not on the affiliation concern. Affiliation they have to give as per the NCT regulation.
Anyway, just a minute.
I will furnish the.
Government has this transaction of business rules, allocation of business rules. How departments are,
Yes, yes.
how they are divided. Do you have that?
That is there.
You can produce that. We'll see from there. It must be clear only. This department deals with so and so, so and so. There's a clear division of the subjects or the departments to be dealt with by each department.
That is why there was communicated to
Ah.
the director elementary. SCRT.
Normally, B.Ed is not the elementary. But since it's a graduate level, so you're saying that it might be higher technical education.
She also mentioned in the application, the communication. Specifically, BA, BP, everything is there, my lord. These are under their control.
I will furnish the 2019 office memorandum.
Yes.
Milord, next.
The office memorandum not work, my lord, because the office memorandum is the office memorandum. That cannot override the statute, my lord.
But nevertheless, we'll have a look at it. We'll have a look at it.
Milord.
Mr. P. Mahanta, learned counsel appears for the petitioner. Mr. P.J. Pugan appears for the Guwahati University. and he shall produce the office memorandum dated 25/2/2019 of the Government of Assam, which is mentioned in paragraph 6 of the counter affidavit filed by the respondent number 2 on 21/5/2025. Stop. Mr. P.K. Bora, Learned Standing Council, Elementary Education Department shall also obtain instructions as to whether the subject of BA, B.Ed, BSc, B.Ed would fall under the Elementary Education Department or the Higher and Technical Education Department. Full stop. For this purpose, the Learned Standing Council shall produce the allocation of business by the state government to various departments by the next date. Yes, any submission?
They have submitted by the affidavit.
Mr. I. Alam, Learned Council appears for the
They
NCT.
are supporting my case, madam.
Anybody else? Mr. H. Borua appears for respondent number 3. SCRT.
They are also supporting my case, madam.
What is the full form of SCRT?
State
State
Council of,
Council for Education Research
And you are for NCT.
this is National
see.
Council of Teachers Education.
I see.
SCRT is under elementary education.
Okay.
That is the
SCRT
problem.
in state level, madam, they are dealing with the, madam, the BA.
We'll list again when?
Madam, the one date may be fixed, madam, because I am.
List the matter again after 2 weeks on a date to be fixed by the registry.
No, madam, date may be given.
Date will give a,
Madam, this-
registry will give a date. You'll come within 2 weeks. All right.
10th of August, madam.
10 to Sunday হয়েছে।
Oh, yes. On 30.
You want to come on Sunday?
Madam, the 30th of August. 30th August, madam.
They'll give a date after 2 weeks. Okay.
Can it be on 18th of May? After 15th of August?
2 weeks, it'll come after 2 weeks.
My lord.
Get your instructions by then.
That will be better.
Well, the date is to be fixed because well, the party well, has already there is an instruction from the Supreme Court an endeavor to be made well, to dispose the entire matter in a very short time. So a lot of time has given after the Supreme Court's order also. That is why I have ordered.
তাহলে 18 or 19 ত লৈ লও। 18 or 19
It is a problem.
দাদার অসুবিধা আছে নেকি? দাদা
18th
18, 19 কিবা অসুবিধা আছে?
Okay, you give a date after 2 weeks.
19/8.
1980.
19th of August.
Must be.
most of them.
But you must get the instruction, otherwise we'll
But,
end up like today only.
For instruction matter, already 2 days has gone. My lord, my humble service on that day, they should come all the preparation, my lord.
Most of them.
One more line, and endeavor shall be made to dispose of the case on the next day.
My lord. Must be.
Item 3.
May I please your lordship? The matter is regarding pension, lordship. The petitioner, lordship, on the last date, honorable court have issued directions to bring instruction regarding non-liability certificate and audit clearance certificate. Certificate.
We have received our instruction, lordship, and we have submitted the original service book and the audit clearance certificate to the director of pension on 2/7/25, lordship. Now the Department of Pension will do the needful, lordship.
Another thing, lordship, here, lordship takes up my affidavit in reply, page 69, there the leave encashment period, that has to be corrected. Page 69, I have stated, lordship, paragraph 7. Clearance certificate. Oh, okay.
Yes.
That has to be corrected, lordship.
But what do you say about this? Paragraph 7. Who will correct this?
Encashment, correct one.
Leave encashment.
It is headmaster already supposed.
Number of days for leave encashment is 175 according to them, petitioner.
Inspector of schools? Oh, Lordship, the inspector of schools will clarify this, Lordship.
Hmm.
Verify, Lordship.
Otherwise, Lordship, certain things are already corrected. After filing of this petition, they have corrected the basic pay was wrong, that was corrected. Only the leave encashment that has to be corrected now, Lordship. That has to be verified and corrected. And Lordship.
Who will do that? Who will do that?
IS will, inspector of school will come, Lordship. He will do.
Can we dispose it of that?
No, Lordship, let it be corrected because the payment has not been made till yet, Lordship. Although these are corrected, the basic pay and all are corrected, that payment has not been made, Lordship. And the petitioner is, Lordship, 73 years old. He is bedridden. So, Lordship, they will take another period of time, Lordship, long period. And Lordship, he had retired long back in 2012, Lordship. And there are orders of this honorable court yet.
How many petitioners there? Only one.
One petitioner.
One petitioner.
Lordship. Lordship may fix a short date and let them clarify the thing and.
What is your prayer otherwise? Let's see.
Lordship, prayer is at page 16, Lordship. Page 16 of the writ petition, Lordship. Lordship, direction to the respondent authority to pay the time scale promotion deducted amount of 50%, 25% at the time of suspension period with effect from so-and-so to so-and-so along with increments, final payment of DCRG and final leave encashment benefit. Leave encashment benefit that on Lordship, the days have to be corrected. And final pension. Final pension is paid, Lordship, the basic pay was not corrected. That was corrected recently, but payment has not been done, Lordship.
What is your good name?
NM Sharma, Lordship.
Miss NM Sharma
Lordship.
submits that learned counsel appearing for the
Secondary education.
Secondary Education Department submits that as per the instructions received by her, the Inspector of Schools, KDC Amin Gaon, has submitted the service book and the audit clearance certificate in respect of the petitioner to the Director of Pension Assam on 2/7/2025. Stop. In this connection, she has produced the communication dated 17/7/2025. Written to her by the Inspector of Schools, KDC Amin Gaon. Miss
A. Talukdar.
A. Talukdar, learned counsel for the petitioner, submits that there has been a mistake in the number of days calculated for leave encashment by calculating the same as 110 days. She submits that the actual number of days for leave encashment should be 175 days. And the period for such calculation is with effect from 15/6/1995 to 31/12/2012. Next para, considering the above submissions, matter stands adjourned for 3 weeks to enable the respondent authority concerned to finalize the dues of the petitioner it is also made clear that the inspector of schools shall look into the mistake said to have been committed in the calculation of the number of days for the purpose of leave encashment. List again after 3 weeks on a date to be fixed by the registry. The communication dated 17/7/2025 produced by Lanet Standing Council, Secondary Education, shall be retained and record and marked as X for identification. All right.
Much obliged, Lordship.
Item 5.
May please, Your Lordship.
Yes.
This is matter relating to family pension. The husband of the petitioner was working as lecturer at DR College, Golaghat. He joined in the year 1963, my lord. He served for 23 years as lecturer in the college in a sanctioned post. He got voluntary retirement in the year 1987. At that point of time, the college was deficit college and no pension scheme was there. In 2005, an enactment was there, my lord, known as Assam College Employees Provincialization Act 2005. Wherein, my lord, Lordship will get in paragraph 4 of my petition. Paragraph 4, page 5, my lord. Government of Assam in the year 2005 enacted a new act in respect of provincialization of services of the college teachers, viz. the Assam College Employees Provincialization Act 2005. Section 3D of the said act provides that the existing employee who wants to continue in the existing terms and conditions of the services shall give an option in writing to the Director Higher Education, Assam, within a period of 3 months from the date of coming into force of the act, provided that the option once exercised by an existing or retired employee may be withdrawn by him at any point of any time if he wants to come under provincialization under this act, subjected to refund of the amount of government shares of the contributory provident fund with interest thereon, up to the date of refund of the government share of the contributory provident fund with interest. It is further provided the withdrawal of options shall be effective on the date of refund of the amount of the government share of contributory provident fund with interest thereon. My lord, at that relevant point of time, petitioner was a retired person and he was sick, so he could not opt for the option. He was not aware about this act. Nothing can be done, my lord. He was a sick person. This act was thereafter, my lord, amended. Section 8, Lordship may kindly go. Mode of pension to employee who retired died prior to 1st January 2005. Employees who retired died, as the case may be, prior to 1st January 2005 shall be given only superannuation pension or family pension. There is a provision for payment of pension to the employee who retired or died prior to 2005, my lord. As may be applicable under the existing pension rules of the government, they shall not be entitled to any other pensionary benefit, provided that the payment of such superannuation or family pension, as the case may be, are subjected to refund of government share of their contributory fund within 6 months from the date of coming into the force of this act, my lord. As he did not, my lord, 6 months passed, he could not deposit the 50% of the contributory fund. Thereafter, in 2010, this act was amended and the 6 months was extended for another 6 months, my lord. At that relevant point of in the year 2008, he died. This time also he could not exercise this power, this act, my lord. In 2012, my lord, the act has been amended again.
Lordship may kindly find at paragraph 5 of my petition. This is 12 rule, my.
2012 Act. Is it?
Yes. Paragraph 5 of my petition.
In fact, it's the 2005 Act,
Yes.
amended in 2012.
12, yes.
Let us see that 2000,
Paragraph 5, Mary.
you have abstracted.
Yes.
Prior to 1st January 2005. Your husband retired on voluntary retirement
Yes.
on 17/2/87.
87.
87. He was allowed to retire.
He was allowed to retire.
Then he expired in 2008.
8. There's a letter, Lordship will find Annexa E.
And what was his mode of service? He served for about 23 years. As what? On contract basis,
No, in a sanction post, regular basis.
regular basis,
Yes.
but not in a provincialized college.
No, at that time colleges were deficit system.
Deficit, okay. And there's no pension for that.
And no pension. Only after 2005 pension provisions has been made,
Okay.
after this act.
But whether this act will apply retrospectively?
Yes, here only in 2005 itself says that retired before 2005 pension will get, my lord. Persons retired or died before January 2005, pension will get, subjected to refund of the contributory fund. my lord.
Where is the act itself? Show me the act.
Act, I have, my lord, annexed in my reply. I have filed a reply lawsuit.
There's a book on this. What is the act called?
Page, my lord,
Assam College Employees Provincialization Act. It's not in this.
page 67.
This is what? Page 67.
Reply to my reply to the affidavit filed by the government.
Page 67 is the affidavit in reply.
Yes,
Where have you annexed? I want to see the act.
the act I have, act of 2012, I will annex, my lord.
Where?
Here, my lord, this is
Where means where? Here means where?
with my reply, lordship.
No, you have
College employees provincialization.
you have abstracted it.
No, the portion I have annexed.
I have not seen that. Well, page number?
Page number 67 in my. Huh? 67.
This one. Education manual. Do we have education manual?
I'm checking it out.
Page page 288.
8. Rule 8, my lord. Mode of pension to employee who retired, died prior to 1st January 2005. Two 2005, my lord, this is, I am reading is 2005 act, ma'am. Eight. Mode of pension to employees who retired, died prior to 1st January 2005. Employees who retired, died, as the case may be, prior to 1st January 2005 shall be given only supernumerary pension, superannuation pension, or the family pension, as the case be applicable under the existing pension rules of the government. They shall not be entitled to any other pension benefits. This is basis. They said nothing. They said that this is not applicable to the retired employee. Only existing employee will get.
Now,
2005, after the act. Yes, yes. Yes, this section has provided that they are entitled for pension. Impugned order, Rossip will find. 49 page number of my read petition. This is typed copy. And the annexer K. Originally 51. Yes. It is, yes, in the reply, Lordship. Page 68 starts. Here, Lordship will find. Provided that option once exercised by an existing or retired employee may be withdrawn by him at any time if he wants to come under provincialization. Under this act, subject to the refund of the amount of government share of contributory fund.
This is amendment of which act?
2005 Act, my lord.
With
In the
which section? Section 3.
3.
No, how is it relevant to your case?
She is entitled by this act, the amendment, and she became eligible for pension.
How?
Because the time limit for submission, depositing the contributory fund, government shares of contributory fund has been extended and it removed, and at any time they can, accordingly, she has already deposited the contributory fund and college authority accepted the same.
You have deposited back the
Yes. I have
CPF.
deposited
CPF you deposited back.
government share.
How much was that? Was it
That was-
quantified?
That was there, annexer D, Lordship.
Annexure B.
D, page 31. By way Treasury Salon.
Annexure B or annexure D?
D.
D for Delhi.
31. Thereafter, pension papers were sent to AG for pension, but that was returned by the AG office.
What is that option?
Option to continue as existing system or to come under provincialization.
Existing system is what?
What was going on before 2005?
What was that?
Deficit system.
Deficit system. But there was no option. 2005 only provincialization came, isn't it?
Yes.
So where is the question of option? There was only one choice. That you are in deficit.
Persons who are under deficit, they have to deposit the contributory fund, government share of contributory fund. To come under provincialization.
This annexure D is the share of the government.
Annexure D is the share of the government. D. If lordship go through the annexure E, my lord, the letter from the director. F, annexure F, page 40.
Government's share with interest, it says.
Annexure F, lordship mechanism,
Annexure F.
page 41.
What is that?
This is a letter from the Director of Higher Education to the Commissioner and Secretary, Government of Assam Education Department. My lord, may I read, lordship?
Yes.
With reference to the subject cited above, I am directed to forward herewith a pension proposal in respect of late Shiva Prasad Thakur, ex-lecturer DR Golaghat, as instructed by AG Assam, write his letter under reference above. In this connection, it may be stated that late Shiva Prasad Thakur was released from service from DR College on his own VRS request with effect from 1/1/1987 by the college authority, and this has already been recorded in his service book. Late Shiva Prasad Thakur had been working as a lecturer in DR College, Golaghat, with effect from 3/10/1963 to 31/12/1986 against sanction post, and his appointment had been approved by DPI Assam, right letter so and so.
What is DPI?
Director, my lord, public instructor, Director Public Instructor, I think. At that relevant Director, Education was not there. DPI was there. Director Education came later on, my lord, this post. DPI post was there instead of Director Education. And the same had also already been recorded in his service book at page so and so. As such, it has revealed that late Shiva Prasad Thakur was in regular service more than 23 years. It is obvious that at the time of his release from service, VRS was not in force in case the employees who were working in GIA College under deficit system. So DHE Assam could not consider the same, owing to the fact that grant of VRS with effect is not possible at present. However, after a long interval from 87 onwards, Shiva Prasad Thakur expired on 5/1/2008. Unfortunately. In the meantime, having coming to know from a reliable source, Mrs. Nijala Thakur, wife of late Shiva Prasad Thakur, had deposited 50% of government share of CPF money by Treasury Salan in pursuance to the government notification dated so and so. This is, my lord, the amendment portion, my lord. With a view to enjoy pensionary benefit and applied with all relevant documents treated to have been obtained. Now, considering his past 23 years continuous service and on the basis of the Treasury Salan, the government is requested to accord necessary permission for approval of family pension against the deceased person at an early date. This is the letter from the director, my lord. Annex G also, my lord, same type of. One more letter is there, my lord. I have filed in reply, my lord. It is was given by the AG office. And page 70 of my reply, lordship. It is from the Accountant General Office, my lord. Page 70 of my reply, my lord. Page 7 has your lordship got. Date is 4/6/2024.
In my copy, it's page 80. It's been renumbered, it seems. Annexure O, isn't it?
NXRO.
It's page 80 for me.
Sorry.
Yes. What is there out here?
My lord, this is a letter from the Accountant General Office, my lord, to the Secretary Government of Assam Higher Education Department. Subjective pension case in respect of late Shiva Prasad Thakur, ex-lecturer, DR College, Gulaghat. I am to invite a reference to the letter dated so and so, wherein it seems that the Director of Higher Education Assam has clarified the status of late Shiva Prasad Thakur, ex-lecturer, DB College, Gulaghat, as sought by the government. If the government has already considered that option holder to those cases who have already refunded the CPF money beyond the stipulated extended period can be allowed pension, family pension, under the similar criteria of fairness and justice as proposed. May please be issued necessary instruction to the Director of Higher Education, Principal, DR College, Gulaghat, to forward the family pension papers with requisite documents and service book in complete and correct shape as claimed by Thakur with effect from Shiva Prasad Thakur. This matter issued by the Accountant General Office, because similar cases has already been government decided, allowed.
What is that?
Here it is said, the persons who deposited the
No, that similar case where government has decided. Do you have that?
here it's mentioned by the Accountant General Office, lordship will find
Where?
I am to invite a reference to the letter dated so and so dated 1/9/16, wherein it seems that Director of Higher Education Assam has clarified the status of Shiva Prasad Thakur, ex-lecturer, DB College, Golaghat, as sought for by the government, if the government has already considered as option holder. To those cases who have already refunded the CPF money beyond the stipulated extended period, can be allowed pension, family pension under the similar criteria of fairness and justice as proposed.
No, this has nothing to do with similar other cases. You say that similar other cases have been decided. It only says that if the government has considered considers necessary, considers it proper in view of the amendment of 2012, then instructions may be given. Any other similar case has been decided like you,
Yes,
like your case?
and in my reply, my lord, some persons, my lord, paragraph 10, my lord.
Just statements only.
Statement.
You don't have any documents as such.
Document I don't have, my lord.
Par-
Page 62, paragraph 10 of my reply.
Paragraph 10 of the reply.
Page 9. Nine. Yo. Kita pakai hukuman puluh. Paragraph 10, Lordship, I have made this statement. The opponent states that widows from the following lecturers who have working with late Siva Prasad Thakur, the husband of the petitioners, have already been received the family pension. These are names I have mentioned, my lord.
Names are there, but I don't know what is the facts behind.
My lord,
You
when,
don't know.
whatever may be, my lord, when there is amendment in 2012, my lord, thereafter, after the amendment of 2012, the petitioner became eligible. And she has already deposited the amount as per the direction of the college authority. Only thing government has to approve a poor lady, my lord. And her husband served for 23 years in a sanctioned post. As he was sick, he could not apply at the relevant point. The only thing is that she is late. Her husband was sick at the relevant point of time, so she could not apply. That is the problem, my lord.
When did she apply?
She applied in 2012, after the amendment.
And refund took place when?
Refund, my lord.
2012, Lord. 9/11/2012.
2012.
AG has said for fairness and justice. This is only for fairness and justice. Delay has to be condoned, and my lord, she will get a little amount of pension, my lord. In the fag end of her life.
See, by this act of 2005, the college was provincialized.
Yes.
Where's that? Any particular notification?
No. College was not, the services of the employees of the college, my lord, was provincialized.
No, he retired before that, no? On
Yes.
voluntary retirement.
Yes.
He was not provincialized
But-
during his lifetime.
The act provides that retired person or died prior to 2005 is eligible for pension. But they have to deposit the this contributory fund within a period of 6 months. They are eligible for pension. 2005 Act provides that, my lord. Paragraph 4.
What is the purpose of provincialization? On what is the benefit that you get?
They are getting, my lord, scale of pay and their pensionary benefit, service provision.
Your husband was not getting scale of pay,
Yes, he was getting,
but he was not provincialized, isn't it?
not provincialized.
So is there
Grant
any
in aid, government gives some grant in aid.
grant in aid? Grant in aid to the college.
Yes.
It was not a provincialized college. Grant in aid college.
All colleges are grant in aid college prior to 2005.
Hmm.
All colleges, there are few government colleges like Cotton College,
Hmm.
Diffu College. All colleges are same.
And grant in aid colleges employees will get pension or not?
They do not get pension. They get contributory provident fund. The
Okay.
contributory fund, they deposit and same amount government gives to them.
Matching amount. But now you're seeking pension on what basis?
On the basis of this act,
Okay.
this act provides that the retired person are entitled for pension if he deposit the government shares of contributory fund.
Hmm.
This act says. This act clearly says the retired person, died person entitled for pension if he deposit the 50% of the contributory fund. Government share.
But is it not meant for the provincialized government servants, provincialized employees?
Provincialized employee will automatically get mentioned.
Hmm.
After 2005, the employees who are working on the
Correct. So provincialized employees will get the pension, but your husband was not provincialized. His service is not provincialized.
the retired person or died person who deposit the 50% of the contributory provident fund, that is the government shares of contributory fund, entitled for pension. But initial stage, there was a limited period of 6 months.
6 months. Where's that?
This is my lord lost paragraph 4 of my petition.
Paragraph 4. Section 3D. You're referring to section 3D.
3D.
So Act came into force in 2005
Yes.
and employees required to give an option within 3 months. Correct?
Mm.
But this 3 months time has been extended.
This 3 months has not been extended for depositing the amount for 6 months. That has been extended. Last portion.
No.
That the options on exercised by an existing or retired employee
Maybe withdrawn by him at any time.
at any time.
So
He wants to come under,
there's no limitation.
yes, provincialization of the act. If he wants to come under provincialization, subject to refund of the amount of government share of the contributory fund, which interest thereon, up to the date refund government shares of the contributory fund with interest. If it is further provided that the withdrawal of option shall be effective on the date of refund of the amount of the government share of the contributory fund with interest. Section 8 provides mode of pension to the employee who retired, died prior to 1st January 2005.
What is the reasoning given in the impugnment letter? Page 49.
The
Retrospective,
provisions of Assam College Employees Provincialization Amendment Act 2012 is not applicable to late Shiva Prasad Thakur. That is the impugned order.
it cannot be given retrospective effect, they say.
They said, but the act provides the retired person is entitled for pension, subjected to refund of the contributory fund. How can they say that this is not applicable when the act itself says?
Option to continue or not to continue with the existing terms and conditions, which is applicable only to existing employees.
Act said for retired employees. Page 6, Section 8, Lordship. Page 6 of my petition.
Yes,
Section 8, my lord.
yes, you
Due
have
to
read.
pension to the employee who retired prior to 1st January 2005. This is my,
That you have read. So you're relying upon this
I
and the
read-
amendment.
yes.
Then although your husband may have died after getting VRS, but in view of this 2005 Act, he's eligible to get pension.
2005, he's a retired employee of the college.
Hmm.
And so he is eligible.
There's no bar.
There is no bar. But the impugned order said that this is not applicable to him as he retired this act has not provided any time limit. Retired prior to this year or that year. It is nothing. All retired persons are entitled.
Amendment says subject to refund,
Subject to
and
refund.
you have also refunded. And you have taken the name.
That funded late. So government has to approve that.
Where is the?
Objection that
Oh.
funded, this is the objection of the accountant general, that there is a delay.
You have already deposited, isn't it?
Yes, I have deposited
Where? The treasury?
through treasury, registrar.
Under which head? To whom? Where is that page number?
Annexer D,
Annexure D page number? D. CD. Ah. Which the one?
31.
To whom have you, to whom, where have you deposited?
To treasury,
Through treasury to whom?
State Bank of India, to the principal, DR
No.
College, Golagat. Government share of CPF.
By whom tendered is there, then number two is the name and designation of the person on whose behalf money is paid. Principal of that college. Then particular is government share. Where is the pension, where is the service book of the petitioner? Left. Husband of the petitioner. No, it's lying with whom?
The college authority.
With the college. Has it been forwarded?
Yes.
And rejection came from the director or what?
No, rejection came from the AG, Accountant General. Director has, my lord.
No, rejection came,
Problem.
rejection came from the additional secretary, higher education.
Initially, pension papers were forwarded to AG. AG returned back the proposal with a request to forward the same through government. Government.
Where is that? Where is that? Aegis letter.
That AG's letters, first AG's letter is not with me, but it reflects in director's my lord letter. Annexer F,
Where?
Annexer F, page 41. Fifth paragraph. Sixth paragraph, loss will find. In the meantime, having coming to know from reliable source, Mrs. Nijara Thakur, wife of late Shiva Prasad Thakur, has deposited 50% of government share of CPF money by Treasury Salam in pursuance of the government notifications of so and so, in view to enjoy pensionary benefit and applied with all the relevant document treated to be have been opted. Now, considering his past 23 years continuous service and on the basis of the Treasury Salam, the government is requested to accord necessary permission for approval of family pension against the deceased person as early date. This is one of, another letter is there, my lord. Page 42, this is also a letter from the Director of Higher Education.
This has gone from, it came from the AG's office. And perhaps AG has said that you have to get the government approval.
Yes.
So director wrote to the commissioner
Yes. For approval.
on 2 occasions.
Three occasions, my 3 letters are there.
2110, 12, 11,
2014.
and
And one more letter is there, my lord. This is 14/11/2014.
what about annexure G? This also.
Yes.
No, annexure G is,
G is from Director of Higher Education to the Commissioner and Secretary.
G is a type, there's a type copy and an original copy.
Copy is there, but originally is also there.
Then H is also there.
Yes. Here, Lordship will find the case of pension, Annexure G, page 42. The case, the said pension case was returned by the AG Assam with objection that the provisions of family pension or pension for deficit college teachers was not enforced at the time of release of Shiva Prasad Thakur on VRS, that is Iman. And therefore, the request for granting family pension to the applicant could not be considered. It was further remanded by the AG that there was a delay for 6 years in claiming pension, family pension, for which the pension case should have been routed through the government. This is the reason, madam, as per guideline and norms. Government has rejected the plan.
And the only decision available is annexure K. Correct? Any other decision? No.
No. Annexure K. Rejection order, my lord. The Act clearly provides that retired employee is entitled for pension.
Yes.
And recently, my lord, AG as lordship has gone through page 70, annexure O. AG has supported our case. AG said for justice, and my lord, she may be given pension, my lord. Government has to approve her pension.
For justice, not for the provision.
No, similar cases are there. So AG is writing this letter in support of us.
A similar case is not available, no? That's the problem. You have taken few names, two, three, four
Yes.
names,
Yes.
but we don't know.
Paying for the college can bring instruction on that, on whether they are similar or not.
College.
College number, পড়াশোনা number.
Why don't you get some documents
PJ Saika is there, my lord, advocate.
for the college?
Yes. He is not present today.
Debraj Roy College. Is his name shown?
Some question, I think.
Hmm. He's not here today.
I'm not here.
Hmm.
To obtain the instruction.
কোন question?
If similarly situated persons have been granted, then I think similar consideration can be done.
Done.
Then we need not go into all the details.
Clearly provides the retired persons are entitled, family pension entitled, subjected to refund of the contributory fund, government share of contribute, and that has been refunded
Refund can be done at any time.
at any time. Earlier, it was fixed for 6 months, but that has been removed by 12 an amendment. So petitioner eligible for refund.
Six months was prescribed by under what provision?
2005 rules,
Which section?
8.
Section 8.
Eight.
8 is there, my lord. Page 67 of the reply.
Within 6 months from the date of coming.
That was extended for another period of 6 months by amendment of 2010. And ultimately in 2012, that 6 month was removed, my lord. At any time you can deposit.
At any time you can refund and go for the pension. Government.
Lordship, at any point is not very clear, Lordship. And Lordship,
Then what is this amendment?
And Lordship, moreover, the amendment says that CPF, the amount of government share of the CPF shall be deposited with interest, Lordship. But Lordship, if we look at annexure F, even if we look at Lordship, the Chalan, Lordship, at page
No,
31.
don't go into the technical part of it. If interest is required, she will give some
Yes,
more
but
interest also.
Lordship, this
Then you
actually,
give pension.
this will not be applicable to her because this is
Why?
2012, Lordship. The government employee died in 2008, Lordship. And Lordship, this refund was never done by the Lordship government employee. It was done by the wife, the petitioner, Lordship.
But
And
does
he
it
was
say
alive.
like that?
No, Lordship, he was alive. He died only in 2008. This came in 2005, Lordship.
Mr. Upamanya,
Yes, Lordship.
you go by the impugn order. Rejection is not on that ground, that it is not the pensioner, but the wife was returned, so we cannot accept. It's not like that. It just
Lordship.
says that act is not, law is not retrospective, then
And he was not an existing.
option was only for existing employees.
Yes.
Existing employees will of course give option, but those who are not employees anymore,
Employee,
They
the
will
retired
just-
employee.
the retired employee will just refund the amount of the CPF and get the thing.
Lordship, that instruction I can get, Lordship. Moreover, she is claiming that some similarly situated persons have also been given that relief, Lordship. So that instruction the college authority will provide, Lordship. Because the council is not present today. And,
What instruction you want to take?
no, she submitted that the similarly situated person.
That is one aspect. You
Yes,
said
and Lordship, this is whether, Lordship, only existing employee. Whether only this was the impugn order. Why it was, Lordship, what is the consideration, Lordship, while passing this?
But section 8 is clear. Employees who retired or died, as the case may be,
Yes, Lordship.
prior to 2005, shall be given this superannuation pension or family pension.
Lordship, page 7, Lordship.
And is subject to refund of the share of the CPF.
With interest, Lordship, next page, Lordship, page 7 of the petition, Lordship. The first paragraph, Lordship.
7 of the writ petition.
Yes, Lordship. Provided, may I read, Lordship?
Why don't you read from the reply?
Ye-
They have annexed it.
Yes, Lordship.
Petitioner has annexed it.
Page 67, Lordship.
Yes.
Provide, Lordship,
Hmm.
8, Lordship, the last part.
Hmm.
Provided further that if the government's share of contributory provident fund is not refunded in respect of a retired/deceased employee within the aforesaid stipulated period, no superannuation pension or family pension shall be admissible in respect of such employee. Lordship, so she is not eligible, Lordship.
So
Entered in 2012.
aforesaid stipulated period is what, 6 months, isn't it?
Yes, Lordship.
Now,
2012, Lordship.
2010, there was some amendment of
2012, Lordship.
extend.
2010, there is amendment.
She said that there's an amendment 2010 extending another 6 months.
Yes.
But in 2012, one more amendment,
Yes,
which now doesn't say anything.
But,
Lordship, page 69, page 69,
Lordship,
page
the
69.
person has already expired, Lordship, in 2008, Lordship. prior to
Provided
this.
that the options once exercised by an existing or retired employee may be withdrawn by him at any
Person
time.
expired, correct,
Yes.
So, Lordship,
but wife is there to
Wife
get
it is
pension.
only for the government employees, Lordship,
See,
not for the wife, Lordship.
wife is he's entitled for family pension after the husband marriage.
See,
2012, Lordship.
section 8 says superannuation pension, number 1. It also says family pension. Government employee does not get family pension. He gets superannuation pension. His spouse will get family pension, isn't it?
Section of 6 months to 9 years.
And it does not, it covers a retired government servant. It covers a person who has expired already also. So that's why the term is retired/died.
Died.
But, Lordship,
So whether you can deny the pension or not.
but Lordship, the amendment does not say that it should be, it doesn't say that any time they can refund, Lordship. The 6 months will prevail, Lordship, because in the amendment, Lordship, it is silent about it, Lordship. There is nothing, time limit is not given in the amendment, so.
So
Lordship,
if there's no time limit, then
and 6, the 8 will remain, Lordship.
Huh?
6 months time will remain, Lordship.
How
Since
is
that
the
was not
government
amendment.
ship?
amendment of section 3.
69, Lordship, page 69 of my reply, my lord.
amendment is
2020.
in respect of section 3C, Lordship. So 8 is not,
Clause D. What is amended here? Section
3C, Lordship.
3,
Below the treasurer provider provided.
for
that-
the existing clause C, the following shall be substituted. Section 3, C. C has been substituted.
Next paragraph, Lordship.
Then,
D,
uh,
D, my lord,
in clause D,
D.
and in clause D,
Provided that the options once exercised by an
for the
existing.
existing proviso, the following provision shall be substituted. In clause D. So this D, below D, there's a proviso, isn't it?
Yes.
Yes.
Provided that. This has been amended.
Yes.
By this provided option once exercised by an existing employee may be withdrawn by him at any time. If he wants to come and under the provincialization under this act, subject to refund of the amount of the government share. It does not give any period,
Time limit, yes.
limitation period.
That made the petitioner eligible for employment.
Insofar as existing employees concerned, they have to give an option within 3 months. You want to come under this or that? 3 months, they'll do that. But for those who have already retired, and if they want to enjoy the pension, they should return the CPF. That's all.
Yes, Lordship, but only the employees, Lordship.
No, when you say employees, you have to look into this clause, sections 8 also. It does not talk about just superannuation pension. It covers family pension also. Do you mean to say once the retired employee expires, pension will be stopped?
No, Lordship.
Wife will not get.
At 2005, Lordship, in the year 2005, he was there, Lordship. He never paid the CPF amount, Lordship. From 2005 to 2008, he was there, Lordship. He never approached to pay, Lordship. And Lordship, this has been paid by the wife only in the instant of the college, not on behalf, not on. It was only the college authority who have requested her to pay the CPF amount. The government has never asked her to pay the CPF amount.
As she is eligible, she has been requested to.
And
deposit
Lordship,
the
the
amount.
page 70 also says, Lordship, the age is later, Lordship. From it says if the government has already considered as option holder, if Lordship. So the employee was never considered as an option holder, Lordship, at the first stage, Lordship. The government has never considered the petitioner as an option holder, Lordship.
That's why petitioner is before your lordship. That's why the petitioner is before your
Otherwise, Lordship,
lordship.
Option holder is for those serving employees, giving option A or B. But for those who have retired or who have expired, they want to come under this provision, they have to refund the CPF. That's all.
Right.
Which means that returning means opting.
Opting.
Returning of CPF is equal to option.
No, option is whether they will have the new benefit or the CPF. They have the option for 3 months to choose whether they want to carry on with the CPF after retirement.
3 months is for the employee,
Yes, Lordship.
serving employee.
Yes, serving employee.
Petitioner's husband was not a serving employee anymore. He retired or expired also. So whether he should be given the family pension or not is the question now.
Lordship, I'll have this specific instruction in this point, Lordship. And Lordship, these people that she has named, Lordship, in her reply, Lordship, we are not aware, Lordship, when they applied, Lordship, and what is their, when considered, Lordship.
You also get instructions?
Yes, Lordship.
Since Mr. who is not there?
No, he is here.
Oh, Mr. Saikia, you are for the college. In the reply affidavit, petitioner has taken 2-3 names, saying that they are similarly situated and they are also enjoying pension. You just have to get instructions whether they are similarly situated like the petitioner. Bonti Tamuli, Malabika Das, and then Amiya Tamuli.
And Anjali Gohai.
3 persons. The Anjali Gohain is also there. Please write down. Parties are represented by the respective councils. Stop. The issue to be decided in the instant case is as to whether petitioner who retired under the voluntary retirement scheme, open bracket, although not in existence at the relevant time, close bracket, and who has subsequently expired can be covered by the Assam College Employees, open bracket, Provincialization, close bracket, Act, 2005, and its subsequent amendment in 2012. Stop. In other words, whether the petitioner, who is the wife of the late lecturer, can claim family pension having regard to Section 8 of the Act of 2005 and the amendment of the proviso to Section 3 of the said Act by the Amendment Act of 2012. The petitioner has also claimed that similarly situated persons such as Mrs. Bonti Tamuli, wife of late Prafulla Sharma, Mrs. Malabika Das, wife of late Basudev Das, Mrs. Amiya Tamuli, wife of late Kandarpa Tamuli, and Mrs. Anjali Gohain, wife of late Purna Gohain. have been given the benefit of family pension. Stop. Having regard to the above claim, next para. Mr. D. Upamanya, Learned Standing Counsel, Higher Education Department. And Mr. P.J. Saikia, Learned Counsel for the Principal Devraj Roy College, Golaghat, bracket respondent number 4, shall obtain instructions. By the next date. Let the matter be listed again on so and so. 2 weeks will be sufficient?
Let me fix.
2 weeks is enough?
Let
Give it
me
2
fix.
weeks. Well, wait.
Lordship, perfect.
Not required. Will get stuck up just like that otherwise.
Deeply obliged.
Much obliged.
Yes.
Also, this issue pertains to lordship, whether these petitioners, they will be entitled to new pension, under the new pension or a old pension. Lordship, this issue has already been decided by this honorable court. I have come across few judgments.
What is that? What is that?
May I place the facts then the judgment?
No, see the time,
Yeah, Lord.
15 minutes.
I will straight away place the judgment, Lordship.
Can we complete in 15 minutes?
Yes.
Possible. Anyway,
We'll do one thing, you give the judgment and Mr. Bor Pujari also should have examined the judgment and we'll post it again.
Yes, it's a small,
Perhaps.
Lordship, may kindly see paragraph 6.
Absolutely.
In this case, Lordship, petitioners were all appointed in the year 1994, but their service were regularized on 31/2006. That is vital.
Question is whether you'll be covered by old pension or new pension.
New pension,
You're claiming old pension.
old pension.
We'll have it after some time.
Lordship, may I read paragraph 6, small paragraph 1.
We'll have it after some time, not today. All right. Can you check up? This is the thing, no?
6/9.
On which days do we have less case? August, which date?
What's all that?
This is first week, isn't it? This is second week. Okay. We'll have it on 14 August.
14 August.
Counsel for the petitioner submits that the case of the petitioner is squarely covered by the order dated 12/8/2021 passed by coordinate bench of this court in WPC number 8694 of 2018. Open bracket. How do you pronounce this? Sukumar.
Yes.
Sukumar.
Sukumar Sarkar.
Something wrong here. SUKUMAR all joined.
Sukumar Sarkar.
Sukumar.
There's a name like that.
Yes. Sukumar Sarkar.
Sukumar Sarkar and 7 others versus State of Assam and 8 others. Close bracket.
Lordship, may give one more case, review petition filed by the state government, review petition 16 of 2019.
Who is that? Copy.
Yes.
Stop. Also, by the order dated 11/2/2021 passed by coordinate bench in review petition number 16 of 2019, open bracket, State of Assam and another versus same party or what?
No, different parties.
Versus Dilip Kumar Mehdi and 28 others, close bracket. Stop. Mr. R. Paul Pujari, learned Standing Council Finance
Finance.
shall examine the claim of the petitioner through the aforesaid two judgments and make his submission by the next date.
My lord.
List again on so and so.
Okay.
14.
August. Okay. So obliged.
Obliged.
Okay. Bring this now.